the main central idea here was trying to separate the value of a standard, because a standard itself, 802.11, for example, the Wi-Fi standard, has great value in the standard itself. And how much any patent that is essential to that standard is actually worth needs to be separated from the value that the standard itself has provided. And so to do this, one of the things, or the heart and soul of the order that the judge put out is looking at a given patent in Motorola's portfolio and how important that standard was, or how important that patent was to the standard, and how important that patent was to the product that Microsoft was using that implemented the standard. And then the idea there being, if two parties sat down and tried to negotiate a royalty rate under RAND, that would be really what the parties would be looking at. How much do I need these patents? How good are they to the standard? And how good are they to the portions of the standard that I actually use in my product? Because that's what business people would do. And so trying to answer your question, the idea that I think Judge Robart was driving at in this order was to provide not only a framework for analyzing this particular dispute in the lawsuit, but also a real-world application framework for people that are business folks or engineers, with business folks with the help of engineers out there in the real world that we're trying to negotiate for a license to either a cross license or a license to a portfolio of standard essential patents. So that's generally what he was going for, a real world application, I believe.